Speaker. I'd like to speak in the second reading of the Privacy Cross-Border Information Amendment Bill, and I'd like to pay particular mention of the work done on this bill by my colleague, the Honourable Leanne Dalzell, as Commerce Minister and Justice Minister in the previous Labor government, and also I'd like to commend the Green Party today for supporting this bill. I think that shows true maturity, and it's good to see cross-parliamentary support on this issue. It was introduced by the Honourable Leanne Dalzell in the former Labor government in July 2008 and had its first reading on the 1st of April last year, and as you've heard, it was reported back to the House in September last year, and it's taken this long to actually get to this point, which my colleague Charles Chauvel spoke about with some regret. It addresses a number of problems with the Privacy Act, which I'll spell out quickly, but along with launching the Law Commission's review of privacy, which the previous Labor government did, this bill was part of Labor's efforts to update and strengthen privacy law in New Zealand, and which is a very important and significant thing. So ultimately this bill is a Labor bill, and therefore, of course, we support it. You've heard about the two flaws which this bill essentially attempts to correct, which is the flow of people, the increasing flow of people and information across borders, and the privacy issues that surround that. And the first amendment is around the Privacy Act 1993, which introduces new provisions that deal with the cross-border transfer of personal data. And to complement those changes, the bill includes new provisions that facilitate the cross-border enforcement of privacy laws, and that means that it will reduce the likelihood of New Zealand being used as an intermediary for the avoidance of other states' privacy laws. And also, the Privacy Act does not, as it stands, allow foreign nationals resident overseas to make information privacy requests, and further, nothing in the Act prevents data received overseas from being transferred outside New Zealand to a jurisdiction that doesn't have adequate privacy protection, which means that New Zealand is unable to provide the assurance requested by our overseas trade partners that we can fully protect their privacy and their customers' privacy. So you've had that quite well canvassed. So as we've heard, the Law Commission is undertaking a review of privacy values, technology change and international trends, and their implication for New Zealand law. And in February this year, a report was issued titled The Invasion of Privacy, Penalties and Remedies, which complements the bill that's before us today. And the Commission found that New Zealand's privacy laws, in particular those relating to surveillance, are patchy, and I want to talk a little bit about those, and then provide the House with a case study which shows the importance of business failing to keep its information secure. The Commission recommended in that report enacting a Surveillance Devices Act, which would make New Zealand's privacy laws more consistent and make it an offence to secretly film or track people. And when speaking to the release of that report, what's called Invasion of Privacy, Penalties and Remedies, Sir Geoffrey Palmer, the President of the Law Commission, said, "Our laws on this are currently very patchy," and he said that technology is moving so fast and we need to ensure that our privacy is properly protected. And that's, well, it's a given, I suppose, but as he pointed out, it's an offence to record a private conversation and get unauthorised access to someone's computer, but it's not an offence to secretly film them or to use a device to track them. And the Law Commission's report recommended some law changes to fill those gaps, that recommended that it should be an offence to trespass on someone's property, to install a surveillance device to film inside someone's dwelling without their consent, and to install or use a tracking device to track someone without their consent. The police, as Sir Geoffrey said, the police need to get a warrant to do most of those things, and it seems bizarre that the law doesn't prohibit other people doing them here. He noted that several Australian states now have similar laws. That report is very interesting, and in terms of the information and the transfer of data across borders issue, and the importance of business failing to keep information secure. And my colleague in the Māori Party has mentioned the issues around credit cards and the identity theft and those sorts of things. I want to refer to a particular case study, DoubleClick, which in the year 2000, which it's a US online advertising company, found out the hard way what happens when a company gets its privacy practices wrong. And DoubleClick decided it would match the personal information of people it had anonymously profiled online with identifying personal information collected offline by Abacus Data, an aggregator of mail order buyer information that DoubleClick had bought. And not surprisingly, that caused a backlash among web users and people who bought items through mail order catalogues, which drew the attention of the US Federal Trade Commission, led to lawsuits, and saw the dramatic drop in DoubleClick's share price from US $135 a share to around the mid-$30 within 6 months. And a year later, the company dropped plans to merge the data, settled all its lawsuits, agreeing to pay $1.8 million in legal costs, and agreed to purge their databases and conduct an online privacy education campaign. And when that company got sold in 2005, the share price was $8.50 a share, and that's gone basically from $135 a share to $8.50. And there's no suggestion here that the mishandling of privacy was the only reason for the dramatic fall in share price, but it certainly was a factor. And I think that was the point that my colleague Charles Chevelle was making, is that the importance of business being able to function effectively in this environment is very important. So in summary, Mr Speaker, the Justice and Electoral Select Committee's main concern on this bill related to the OEC guidelines, and due to the way that the guidelines were incorporated into the bill, any changes by the OECD to the guidelines would have been automatically incorporated into the legislation, which would result in changes to the statutory framework of the Privacy Act without examination by Parliament. So the committee recommended that the basic principles of national application be set out in a schedule, and that the Governor-General be given the power to make regulations to amend that new schedule to reflect changes made to those guidelines, and those amendments to the new schedule will be subject to the Regulations Disallowance Act 1989, and so will be scrutinised by Parliament. The committee also recommended that it be made explicit in the bill that when determining whether to prohibit a transfer of personal information, the Privacy Commissioner may use the investigative powers in the Privacy Act, just as they can when conducting an inquiry under the Act, which would allow the Commissioner to hear information from any person that he or she considered necessary. The committee received and considered 2 submissions from interested groups and individuals, and heard one as well as advice from the Ministry of Justice. And so for these reasons, and on the recommendation of the Justice and Electoral Select Committee, and again acknowledging the work done by my colleague, the Honourable Leanne Dalzell, and it being brought into Parliament by Labor originally, Labor will be supporting this bill to the stage of the third reading.